Hello, everybody.
Okay, the 20th District Court of Travis County is now in session. The Honorable Jessica Mangrum presiding.
Good afternoon, everyone. Welcome to the 200th. I don't have a cause number because the filing hasn't been accepted, but we're here in Texas House of Representatives. Representative Moody, Chairman of the House Committee on Criminal Jurisprudence, and Representative Jeff Leach versus TDCJ and the Texas Department of Criminal Justice Correctional Institutions Division. Who wants to introduce the folks that are going to be participating?
Your Honor, I'll do so for the plaintiffs. I'm State Representative Jeff Leach, Chairman of the House Judiciary Committee, and I believe that Chairman Joe Moody is on this Zoom as well. And then former Supreme Court Justice Dale Wainwright is present for the plaintiffs as well.
All right, and we have someone here from the Attorney General's office.
Your Honor, this is Ed Marshall. We haven't been served with the pleading, and I have no idea what this is about.
Okay, I think I was under the impression or understanding that it had been shared.
No, it has not, Your Honor.
Okay, let's see, Mr. Leach or Mr. Wainwright, do you have someone who can make sure that that gets transmitted?
Yes, it's my understanding that that the Attorney General's office has been well aware of this issue all day and knew this pleading was coming. Of course, it was just filed within the last, I think, 15 to 20 minutes, and so we're happy to share that with the Attorney General's office. If they want to include the email address in the chat of the Zoom, Your Honor, if that would be acceptable to you, then we can get that over to them immediately.
That's fine. Mr. Marshall, you want to go ahead and do that?
Yes, Judge.
Sorry, I didn't hear the question.
Oh, Mr. Marshall is going to put his email in the chat for you to copy and paste and send him the application.
Your Honor, looks like the chat is disabled.
Why don't you just call out your email, Mr. Marshall?
Okay, it's rough.
Thank you. All right. So I have had an opportunity to review the petition and the application. Who wants to speak to or lay out the request? Mr. Leach or Mr. Moody?
So, Your Honor, we of course want to allow the Attorney General's office time to review the pleading. If you'd like us to go ahead, we can lay a factual and foundational predicate for the pleading. I think the Attorney General's office has been aware of what's in it. We'll go through it as succinctly as we can. I'm going to defer to Chairman Moody on the generals, and then I'll follow up with some specific remedies that we're requesting of the court.
All right. Go ahead, Mr. Moody.
Good afternoon, Judge. And thank you for having us. Joe Moody, plaintiff in the matter, also served as state representative, Texas House of Representatives, and am currently appointed to serve as the chair of the Criminal Jurisprudence Committee. The Criminal Jurisprudence Committee has jurisdiction over criminal procedure, penal code, punishments, things related to prosecution in the criminal courts that intersect with that subject matter. The oversight that we are given is pursuant to our constitutional authority to draft House rules under Article 3, Section 11 of the Texas Constitution. That's who the committee is. That is what we do. We engage in fact-finding, investigation, understanding how these things work together. The committee is comprised of 9 members, 5 Republicans, 4 Democrats. And yesterday, we held a hearing at the Texas Capitol to specifically discuss Article 11.073 of the Code of Criminal Procedure, which is within our jurisdiction. This is what's colloquially known as the junk science writ or new science writ. This is a provision that's been in the code for 10 years, and it is implicated. It's implicated in Robert Robertson's case, which is a case, obviously, it's become very well known in the last several weeks. Mr. Robertson is an autistic man who is facing execution in less than 2 hours from now. He has availed himself of utilization of the new science writ, and we wanted to explore what was happening in that case, how our statute was being utilized, whether we thought it was being utilized properly or as the legislature intended, if there was some drafting issues with it, or if there's something that was missing, because what we had expected to happen with the legislative intent of that statute, we don't believe was happening in Mr. Robertson's case and in other cases. And so that was the purpose of the committee hearing yesterday, to glean that evidence. We heard evidence from the prosecutor in Mr. Robertson's case, the defense attorney in Mr. Robertson's case, from 4 expert witnesses, 2 of which had evaluated much of the entirety of the medical record in the case. We also heard from legal experts about the article itself and the efficacy of having new science writs and the purpose they serve in our criminal justice system to make sure that we don't make mistakes when new evidence comes forward later after a conviction, or maybe there was new evidence that comes out later where it could contradict what was utilized at the trial stage. That is what we were delving into. At the end of taking invited testimony yesterday, Representative Harrison and Representative Leach made a motion, which is within our rules and which in our statutory authority, made a motion to issue a subpoena for Robert Robertson. That motion was then voted upon by the committee. There were 7 members present at the time of the vote, and that vote was unanimous to issue a subpoena. That subpoena was served upon Mr. Robertson's attorney, Gretchen Swain. The TDCJ was made aware of it contemporaneously, that she had accepted service on his behalf. He was made aware of it as well through communication through TDCJ, and the reason the committee took that action and the legislative purpose behind it is that for us to understand, and Mr. Robertson is in a unique situation to understand this particular Code of Criminal Procedure provision. He is an autistic man who can talk through with the committee the investigation that he went through, the prosecution, and the appellate process, and whether and to what extent he felt there was due process or how his rights were respected or not respected in that process. He is uniquely situated to be able to give this information to the committee which is within its jurisdiction. We have statutory authority to issue these subpoenas. We issued in this the case. Obviously, this is a unique circumstance in that we can only post notice for a hearing 5 days out in advance. We have done that. There is the hearing that has been posted for Monday the 21st at noon, and we have the subpoena is issued for Mr. Robertson to appear there. We've also issued a writ of attachment tied to that subpoena, exercising our authority to investigate fully this topic. We also know that to be able to understand, there are a lot of fact issues at play in this particular case. And to understand that, to be able to get to the root of it, we do have to be able to judge his credibility. And we cannot do that without speaking to him. And that is the urgency of this petition and the relief we're seeking. That is the posture that we're in today. And I'm going to defer to Mr. Leach on the rest of the request that we are seeking.
Okay, go ahead.
Thank you, Your Honor. Can you hear me okay?
I can.
Okay. Chairman Moody did a great job of covering the factual background and the predicate for our relief today. And without question, Your Honor, this is an extraordinary remedy that the legislature is seeking, but it's not it's not undue. The legislature is allowed this constitutional authority pursuant to the power given to the legislature under the Texas Constitution and our House rules. We, as Chairman Moody indicated, voted unanimously in our Criminal Jurisprudence Committee last night to subpoena Mr. Robertson. At our hearing next week, as Chairman Moody noted, we believe that his testimony is not only helpful for the committee and the legislature, but is vitally necessary. It's our understanding, based on the research that we've done now for many weeks, that his case would be the first case, not only in the state of Texas, but nationally, for any individual to be executed pursuant to the shaken baby syndrome, which the testimony strongly indicated yesterday is now largely debunked and disproven. The legislature has certain interest, and I would say the state of Texas has a strong interest in ensuring that our laws are followed, especially our criminal laws, and our criminal laws relating to someone that's likely to be, or that's scheduled for execution right now in 93 minutes is certainly that the state has a strong interest in ensuring that does not happen, so that we can hear his testimony and judge his credibility. And the legislature intends to hold a hearing to do just that next week. And so, as Mr. Moody indicated, and as the committee unanimously voted, and I would add, as one final note, that over 80 legislators, state representatives, have signed on to a letter calling for the pause button in Mr. Robertson's execution, which is scheduled 93 minutes from now. The legislature believes that his testimony is not only helpful, but is vitally necessary. And therefore, we're asking for this remedy from this court to push the pause button on his execution, so that testimony can be offered in front of the Texas House, and so that we can get the testimony that we need from Mr. Robertson.
This is kind of a Hail Mary pass.
Okay, thank you. And if there's nothing else, we'll go ahead and turn it over to Mr. Marshall at this time.
Judge Mangrum, I'd just like to begin by noting that this is not a shaken baby case. The inmate in this case was not indicted for shaking a baby. He was indicted for blunt force trauma murder of a 2-year-old. The evidence supports the fact there were multiple blunt force impacts to the child's head, and there was a history of abuse from this particular inmate against this child. Shaken baby syndrome just doesn't play a role in this case. So whether or not it's been discredited in the community of pediatric specialists, it's just not the central feature of this case. But more importantly, the Court of Criminal Appeals is exclusive jurisdiction here. They have denied relief in a stay of execution 4 times, at least in the last 6 weeks. Mr. Robertson had a lengthy evidentiary hearing in 2021, at which he was afforded an opportunity to present all of this evidence. It was found to be lacking by the trial court and the Court of Criminal Appeals, and that court's mandate controls here. This court now has a ministerial duty to refrain from acting without jurisdiction, and that is a ministerial duty that is mandamusable in the Court of Criminal Appeals, Your Honor.
Okay, I'm not used to my appeals going to the Court of Criminal Appeals, but I will. Let me ask you this, Mr. Marshall. Is the subpoena sent by the legislature a valid legal subpoena?
Yes, Your Honor, as far as I could tell.
Okay. All right, Mr. Leach, I think I might have interrupted. Was there something you wanted to add?
No, Your Honor, you're not interrupting me at all. I hope I didn't do likewise. I did just want to respond quickly to what seems to be the main position of the Attorney General's office, and therefore TDCJ, their client here, in responding to our motion, in that this is not a shaken baby case. That seems to be the premise and the foundational argument that they're relying on. When the testimony yesterday that was offered to this committee, the appellate record, the evidentiary record, is full and replete of information to the contrary, that this was, in fact, primarily and foundationally and most importantly, a shaken baby case. The lead detective who led this case, who now regrets having anything to do with this case, and other testimony would lead the court to believe, and the fact finder to believe, that this was in and of itself a shaken baby case and nothing more.
Judge, if I just briefly,
Yes, go ahead.
I just want to add a couple of things. And Mr. Moss is correct. There's been an enormous amount of evidence that's been presented. Yesterday, we took over 8 hours of testimony about this particular case. There are a lot of issues to unpack in this case, but they're not the central issue in this court today. The central issue in this court today is the legislature has authority to issue a subpoena to be able to do its job. Our job in this committee has to do with understanding the law that's within its jurisdiction, which includes Article 11.073. The record was very clear yesterday that a different standard than what is mandated by the legislature in the black letter of the law is being utilized in the courts. That is inappropriate. That is improper. And if that is the case, it is absolutely within the legislature's jurisdiction and within our power to be able to look into that. And that is the crux of why we need Mr. Robertson to testify. And no agency, with respect to TDCJ, can stand in the way of a legitimate subpoena that's been issued by the legislature in furtherance of a legitimate legislative purpose. And that's what we have here. People are going to argue about Mr. Robertson's case long after today and what happened and what didn't happen. The experts argued about it for weeks. But the issue today is, does the legislature have the authority to call a witness under a legitimate legislative purpose before it, and whether or not an agency can simply ignore that legally issued subpoena?
Okay, understood. All right, and I'm looking back at the application, counsel, and the relief that has been requested. All right, I don't have anything else for you, counsel. Based on what I've heard this afternoon, the court will grant the TRO. If you could submit an order, I don't think I saw one. Send that over to our office. We'll get it signed.
Judge, if I may ask, we would like a copy of the signed TRO as quickly as possible in order for us to seek our remedies in the Court of Criminal Appeals.
Okay, and do we have your email? Oh, I do, because it's a part of the record, Mr. Marshall. So you will be getting that whenever it's sent out to the parties.
Okay, thank you, Judge.
All right.
Thank you, Judge.
Thank you, Your Honor.
Thanks for your time. You're excused from the virtual courtroom.
Thank you.
Take care.
Be safe, be well, sleep sweet, and much love.